client was facing life in prison. He's at home with his family now, and I'm going to tell you how we got it done. My name is Jamahl Kersey, and I'm the principal attorney at Kersey Law. We're a boutique criminal defense firm in San Diego, California, and in this video, I'll be telling you how we got a client who was facing life in prison out of jail after just 1 year. So our client was arrested for attempted murder, shooting at an inhabited house, and a few other gun-related charges. And the attempted murder charge, because it was considered to be premeditated and deliberate, it had an allegation which meant our client was facing life with the possibility of parole. Additionally, because a gun was actually fired, there was an allegation that added an additional 20 years to the attempted murder. And so when you added everything up, he was facing up to 9 years on the attempted murder plus 20, and that gave you 29, in addition to a couple of the other charges that put him at facing over 30 years to life. In other words, this was a very serious case, and it's definitely not the type of case that you want somebody learning the ropes on. You absolutely need someone with experience when it comes to the life cases. And with that said, if you or someone you know is facing criminal charges in the state of California and you're looking for a winning defense strategy, we can help with that. There will be a link to our website below in the description, and you can go to our website for more information on how we can help. You can also download our report, Fighting Criminal Charges in California. It's packed with useful information and answers to frequently asked questions. And so back to the story, our client's parents, they were looking for the best representation they could find, and they were given our information by another attorney. We get a lot of referrals from other attorneys, which just speaks to our reputation in the community. And so anyhow, they reached out to our firm, and we had an initial strategy session. And after this session, they decided to move forward with retaining our firm, and we got right to work. And our client was a very young man. He had no criminal history. He had no prior failures to appear. So we're talking about arraignment at this point. He had strong ties to the community, and these are all factors that play into whether a person is going to be able to get out on bail or if they're going to have to be detained. And we had a lot of positive letters of support from his friends, family, his pastor, and other leaders. But unfortunately, due to the seriousness of the charge, again, attempted murder, facing life in prison, the DA was successfully able to argue that our client was a danger to the community, and as a result, our client was denied bail. And, of course, people would like to be on the outside rather than locked up when they're fighting their case. That goes without saying, but it really is more ideal to have your client on the outside rather than being in jail. I mean, if for no other reason than just it's so much easier to have meetings with your client, whether that's coming to the office or over the phone or doing a Zoom meeting, which we do a lot of, or if we just have a quick message that we need to pass along or need to get quick information, it's much easier to shoot a text over or make a quick call. But going into this, we knew ultimately we were going to have to handle this case with our client being detained. And so when somebody is detained, we have to balance the interests of trying to move things along as quickly and efficiently as possible, but while still investing the proper amount of time to get the job done right. And this can be a challenge, but we at Kersey Law are always up to the task. And so as usual, we got to know our client, and we obviously need to know our client's side of the story in order to defend them as far as the facts of the case. But we also get to know our clients as a person, right? We get to know, like, what is your highest level of education? What's your work history? Do you have any physical or mental health issues? Does anyone in your family have any physical or mental health issues? Have you overcome any major challenges in your life? What is it that you want for your future? How might a conviction or prison time ruin those plans? And we actually have a lot more questions than that, but you can see just how we get so much useful information in order to tell our client's story. And I say this all the time. Listen, the DA doesn't know anything about a person except for what's in those police reports. And in this case, The police report basically described this incident that our client had a gun on him and he shot at someone. And so what do you think is going through the DA's head when they're reading a report like this? I mean, they're thinking this person's a dangerous individual. He has no respect for human life. He needs to be removed from the streets. And so we need to be able to balance out that information with all the positive information that we can. Eventually, we received the police reports, the witness statements, photographs, and videos, and sure enough, it had been reported that our client shot towards the alleged victim, and thankfully, none of the bullets actually hit the alleged victim. Well, we reviewed all the discovery with our client, right? And this way he would be well informed of the evidence that the DA had against him. And this is something that the client has a right to know. They have a right to know what the evidence is in their case. And we get a lot of calls from people who are unhappy with their current counsel, and whether that's they're represented by a public defender or even a private defense attorney. And the biggest complaint that people have is that they have no idea what's going on in their case. They feel like they're completely in the dark. And so we take the time to go over the evidence with them and answer their questions so they know exactly what's going on. And so while we're going through this evidence, I mean, we're also explaining the law and how it applies to the case. So a lot of times people are going through this situation for the very first time and they have no idea what to expect. They don't know how the law works. And so we empower them with that information. And once we review the discovery together, we basically get our client's side of the story. And so just prior to the incident, he and the alleged victim had a text exchange back and forth, and then he went to go see the alleged victim in person. And he confirmed that it was in fact him on the security camera footage firing the weapon at the alleged victim. But his position was that he only did so out of fear for his own life. And so prior to the incident, the alleged victim had made some verbal threats to our client, which he took seriously. And so in the incident, in the altercation, our client actually tried to walk away and defuse the situation, but the alleged victim essentially was ramping up and getting more aggressive. And so in the video, you could actually see our client walking backwards when it was that he pulled out the gun from his waistband, and the alleged victim was essentially walking him down. So client is walking backwards, the alleged victim is walking him down. And so before our client pulled out his gun, the alleged victim had drawn out his own gun. And so client ends up pulling out his gun, fires a few shots, and then took off. Now, law enforcement ended up tracking him down a couple weeks later. He was arrested and taken into custody. The case eventually ended up going to a preliminary hearing. And if you weren't already aware, a prelim is a probable cause hearing for the judge to determine whether there's sufficient proof to show that a crime has been committed and the person accused is the one that committed this crime. And you can see our video in which I explain the preliminary hearing process. I'll link that above. And so in this particular case, the alleged victim testified at the prelim, and he actually ended up revealing that he did in fact reach for a gun and was pulling it out, and that's when our client pulled out his weapon and started shooting. And so the DA's position was that our client had showed up to confront the alleged victim. He was armed with a gun and therefore had in his mind beforehand that he planned to shoot the alleged victim. And at a preliminary hearing, the DA only needs to establish probable cause. Again, just reason to believe that a crime has been committed and that the person charged committed this crime. And based on the testimony and the evidence, they were able to meet this burden. But the real question was, would they be able to meet their burden under the much higher standard of proof beyond a reasonable doubt if this case were to go to trial? When it comes to plea bargaining or negotiations, essentially the stronger the DA believes his case is, the less they're going to be inclined to negotiate. And on the flip side, the more problems the DA's case has, whether they have issues thinking they're going to be able to prove their case beyond a reasonable doubt, or if they have evidentiary issues, maybe witness issues or legal obstacles, then they're going to be more flexible in negotiations. But another aspect is the client's criminal history. Do they have no offenses on their record, or do they have a long string of offenses on their record? What is their story, right? What's been going on in their life? How did they end up in this situation? Where did things go wrong? Are they interested in rehabilitation? Is there any salvaging of this situation or their life? Can we get things back on track and reintegrate the person into society with a solid plan and avoid something like this from ever happening again? Believe it or not, this information can be some of the most powerful elements to a winning defense strategy. And so we took the time to get the answers to these questions. We had Christina, our amazing investigator, talk to our client's parents and some other people who could speak to our client's really good character and those who had a positive impact on his life. And so we got more letters of support. We came up with a game plan moving forward with a couple of alternative options to show what our client was committed to doing if he got out and were to get a second chance. But it wasn't just about the positive information. I mean, the positive information was really powerful, but we also had a solid case for self-defense that we wholeheartedly believed in. After spending a number of hours with our client in the jail, we felt confident that if we took the case to trial, we could prevail on the attempted murder charge. However, trial is extremely stressful for someone facing a serious charge, especially facing life in prison. It is a serious gamble. I mean, if you win, you go home. But if you lose, you're potentially spending the rest of your life behind bars. And so even when you are confident in your defense, it can still be tempting to try and negotiate a deal where even if it means that you're going to spend some time in prison, chances are, that's going to be a lot less time than life, right? So we had a long and drawn out discussion discussing the facts of the case, the law and his exposure and the likelihood of success. And our client ultimately was prepared to take his case to trial, but he just didn't want to have to, right? And this was very understandable. And so what we ended up doing was basically packaging together all the positive information we had put together about our client. And we also laid out what our defenses at trial would be, essentially expressing the confidence that we had that if this case were to go to trial, that we would be able to demonstrate that our client was acting in self-defense. And so the DA in that situation, they would have to prove beyond a reasonable doubt that our client was not acting in self-defense. And so given the evidence and what had been testified to at prelim, this would have been a challenge for them. But, at the same time, you just never know what a jury would do. So we had to admit the possibility that a jury could find our client guilty of this attempted murder charge. So we ended up sending over 50 pages worth of information over to the DA. And this included a cover letter, which basically explained our defense at trial. And it also laid out a plan for the next year to basically ensure that he would stay on point and he would never find himself in a situation like this again. And, trust me, this almost year that he spent in jail was more than enough to send a serious message that, hey, if you're doing the wrong things, you're going to land right back in here and you don't want to be here. So we had our investigator prepare a mitigation report, and this included all of the interviews that she conducted. And it was compiled in a report that was designed to show basically all the good things about our client and the troubles that he overcame in order to really put into context why the incident happened in the way that it did. And we included the letters of support and all of his awards that he had won. And you can bet that this information packet ultimately balanced back out the scales. Again, when the DA was only going off the police reports, our client just looked like a dangerous monster who needed to be kept off the streets in order to keep the public safe. But the information that we provided told a completely different story. And, much respect to our client's parents, the rest of his family, his loved ones. There's just no way we could do our jobs as well as we do without the support. Plus, emotionally, it just really helps our clients when they still have the support and people haven't given up on them, especially if they're detained. And so over the next couple of weeks, I was going back and forth with the DA, and we spent a great deal of time discussing the case. And ultimately, if he was going to do what we were asking for, he would have to run it up the chain to his supervisor. Since our client was facing life in prison and we were asking for just minimal jail time, we really had to make sure that we were giving this DA everything that he needed in order to justify to his boss why he was inclined to do what we were asking for. And that's really powerful. You really want to give them everything that they need in order to, answer the questions that the supervisor is going to fire back. Like, why are you giving such a favorable deal when this guy's facing life? We really need to arm them with compelling information, and we did. And in the end, we were able to convince the DA to agree to a deal in which our client would plead guilty to the lesser charges of assault with a deadly weapon and assault by means likely to produce great bodily injury, carrying a loaded firearm, and resisting arrest, and he would be able to withdraw his plea to one of the assault charges after successful completion of 2 years probation. And at this time, he had almost done about a year in jail. Now, it may sound like he had to plead guilty to a lot of charges, and I get that, but the reality is he did in fact have a firearm on his person, and that was illegal. He had somewhat resisted arrest, and that wasn't ideal. But as far as the assault charges, it was essentially the exchange of the DA dismissing the attempted murder charge, which realistically they could have possibly proved at trial, and this would have exposed our client to possibly facing life in prison. So after numerous discussions with our client and his family, this was hours of talks, we ultimately came to the conclusion that this was the right call, and he would only end up doing just under a year in jail. And there's just no possible way we could have done this without having a full team effort. Our paralegal, Marisa, helped with reviewing the discovery with our client and assisting with the overall strategy. Our law clerk, Daniel, had worked on parts of the mitigation cover letter, and he did a great job telling our client's story from one angle, basically the legal perspective and our defenses. Christina, our investigator, like I said, took reports, compiled the reports, and these were vital to our self-defense theory. My assistant, Patty, supports me with the important administrative tasks, which can be very time-consuming, and they would otherwise take me away from working up my cases. And so all of our victories, including this one, are a team effort, and I'm so grateful to have my team that I work with. And I also really appreciate the DA's cooperation and understanding through all of this. And if he somehow comes across this video, he already knows who he is, but I actually thanked him personally. The reality is when it comes time to fight, we will fight tooth and nail, but not every aspect of defending a criminal case is a fight. Sometimes you're working side by side with the prosecutor for the greater good. And, the experienced, really good DAs who aren't stubborn and driven by ego, they'll work with you when it's warranted. And fortunately for our client, we were working with one of the good ones on this case. Well, that is an extremely condensed version of how we help someone facing life in prison get out of jail after just under 1 year, move on with his life, and get back to the people and the things that he loves. I hope you got something out of this story. And if you have a case that you're dealing with in the state of California, you can give us a call for a free initial strategy session. You'll let us know what the situation is, and we'll let you know how we can help. I want to thank you so much for watching.